Hello and welcome to the channel. It's me, Kristofer Brooks. I hope everyone's keeping well. In today's video, we are going to challenge a deeply embedded societal assumption, and that is that the state has the power to license our way to travel. At the heart of this is a fundamental liberty to travel freely, to move freely, one that has been recognised in common law for centuries and upheld by constitutional, human rights and legal principles alike. But here's the key argument: travelling is not driving. Whilst driving is a regulated commercial activity, travelling for personal and non-commercial reasons is in fact a lawful right that no statute can convert into a mere privilege. And so in this we will explore compelling case law, timeless legal maxims and international human rights declarations to show how licensing schemes, fines and stop and search practices may constitute as unlawful overreaches by the state. This isn't just legal theory, it's a strategic, lawful stance rooted in centuries of jurisprudence and civil liberty. So let's break it down step by step, and thank you to the PMA where I got this from. And I'm hoping to have David on very soon to talk about the PMA, Private Members Association Group, where there's lots more of this that can be found and utilised for your benefit. So let's have a look.
The right to travel is a fundamental liberty, and under both common law and constitutional principles, no statute or administrative body can lawfully convert a right into a privilege and then demand a licence or fee for its exercise. Now I'll construct the strongest possible legal position, grounded in constitutional law, common law, human rights law, and UK statutory interpretation, to refute the idea that driving, as distinct from travelling, is a regulated privilege, and assert that travelling is a right, not a privilege granted by the state. Foundational legal position: the right to travel is inherent common law right to travel. Freely, Arva Nulla, Publishing, Printing and Promotions, Littered, 1973, AC 435. Lord Reed confirmed the common law protects personal liberty unless clearly taken away by statute. Entick v. Carrington, 1765, 19 St. 1029. If it is law, it will be found in our books. If it is not to be found there, it is not law. Maxim, ubi jus ibi remedium. Where there is a right, there is a remedy. Maxim, nullus videtur dolo facere qui suo jura utita. No one is deemed to act deceitfully who exercises his legal rights. Freedom of movement. Article 13, Universal Declaration of Human Rights, 1948, UDHR. Everyone has the right to freedom of movement and residence within the borders of each state. Article 2, Protocol 4 of the ECHR. Everyone lawfully within the territory has the right to liberty of movement and freedom to choose his residence. Though the UK has not ratified Protocol 4, the right is derived from common law, and any legislative interference must be lawful, necessary, and proportionate. Driving versus travelling. Legal distinction. The term driving is a commercial term derived from regulating the operation of a motor vehicle for profit, trade, or hire. The legal definition of driver under the Road Traffic Act 1988 is: driver, in relation to a vehicle, means the person driving it or in control of it. However, a private citizen travelling on the King's Highway for personal, non-commercial purposes is not engaged in any regulated trade. Maxim, quod ab initio non valet in tractu temporis non convalescit. That which is void from the beginning cannot be made valid by time. Unlawful conversion of rights into privileges. The government has created a licensing scheme for an inherent right. This offends long-established principles. 4. Case law. No right can be converted into a privilege. Murdoch v. Pennsylvania, 319 U.S. 1 and 5, 1943. A state may not impose a charge for the enjoyment of a right granted by the federal Constitution. Shuttlesworth v. Birmingham, 394 U.S. 147, 1969. If a state converted a liberty into a privilege, the citizen can engage in the right with impunity. While these are US cases, they uphold universal legal principles reflected in UK natural justice, common law, and the Magna Carta 1215. Torts and offences committed by the state and its agents. If an individual is stopped, fined, or prosecuted for travelling privately without a licence, tort of trespass to the person, unlawful stop and detention. Malfeasance in public office, when a public official knowingly exceeds lawful authority. Misfeasance in public office, the wrongful exercise of lawful authority. Abuse of process, using legal procedure for an improper purpose. Unlawful interference with goods, if seizure occurs. Additionally, breach of Article 8 ECHR, private and family life. Breach of Article 5 ECR, liberty and security. Breach of UK GDPR, if personal data is processed unlawfully by AMPR or DVLA systems. Remedy and defense strategy. Defenses in court include lack of jurisdiction. No lawful contract or commercial activity took place to justify regulatory interference. Ultra vires action. The state exceeded its statutory authority. Void ab initio. All licensing tied to commercial operation, not applicable to private travel. Suggested remedy. Issue a notice of private right to travel citing the above legal basis. Affixed to vehicle. Private conveyance. Not in commerce. Not for hire. No license required. Right reserved under common law. Prepare an affidavit of truth and declaration of status to rebut any presumption of regulated activity.
So there you are. Let me know what you think in the comments. I hope you found that of interest. I certainly found it interesting and fascinating. So look after yourselves, take care, and I'll speak to you all again soon. Bye for now.